A black iron gate stood where open pavement used to be, fresh concrete, new locks, a sign that read, "Private property HOA residents only." 37 years I'd driven that road. Then one afternoon, it was gone. Two men in uniforms blocked my path, hands resting on their belts, acting like they owned something that was never theirs. I stayed calm, I always do. But they didn't know who I was. They didn't know I'd spent 28 years wearing a badge in this county. They didn't know about the deed in my lockbox, the easement recorded in 1987, or the shotgun sitting in my truck legal, registered, and locked in its case. I hoped I wouldn't need it, but the way they were looking at me, I wasn't so sure anymore. My name is Walter Hadley. I'm 62 years old, and I've been a lot of things in my life: a Marine, a sheriff's deputy for 28 years, a widower, a grandfather. But before any of that, I was the kid who grew up on 45 acres at the end of Miller Creek Road, land my grandfather cleared with his own hands back in 1951. Every story has a place that shapes it. Drop a comment and let me know where you're watching from. I have a feeling this one hits different, depending on how much you've had to fight for what's already yours. I had just spent 3 days in Raleigh visiting my daughter and her boys. My youngest grandson turned 7, and I'd promised to be there. The drive home took 9 hours through rain that turned the highway into a gray blur with no end. When I finally saw the development sign for Whispering Meadows, I felt the familiar pull of being almost home. That feeling died the moment I came around the bend. The gate hadn't existed 4 days ago. Neither had the concrete posts anchoring it to the ground. And the two men standing in front of it, they certainly hadn't been there when I left. The taller guard approached my window with a clipboard, his shoulder patch reading Community Security Officer. I knew that title meant nothing under any law I'd ever enforced. "Sir, this is a private road. Do you have an access pass?" I kept my voice level, told him I didn't need one, told him this road led to my property, that 3 generations of my family had used it long before these houses sprouted up like weeds. He glanced at his partner, then back at me with rehearsed patience. "The Whispering Meadows Homeowners Association controls all roads within the development. You'll need to contact the HOA office for a visitor pass." I asked if he understood what a legal easement was. He blinked, said nothing. "I'm just doing my job, sir. Take it up with management." The engine idled. I stared past him at the road I could have driven blindfolded. The dip near the old oak was where rainwater always pooled after storms. The cracked section of asphalt heaved every winter, no matter how many times the county patched it. The long curve where my grandfather told me he'd proposed to my grandmother while walking her home from Sunday service. This wasn't just a shortcut to them. To me, it was everything. And the document that proved my right to use it had been sitting in the county clerk's office since 1987, filed, recorded, and legally binding. I noticed the security camera mounted on the gate post, small black dome, blinking red light. I filed that detail away for later. Then I put the truck in reverse, turned around, and drove 12 miles out of my way to reach my own front door. 12 miles of detour to enter land that had belonged to my family before any of these people learned to spell Homeowners Association. That night, I pulled out a metal lockbox I hadn't opened in years. My grandfather kept everything important in there: the original deed, survey maps, correspondence with the county going back decades. Near the bottom, I found what I was looking for, the deed from 1987. That was the year he sold the front parcel to a developer named Harrison Locke, keeping the back 45 acres for the family. The sale contract included something Locke had to accept as a condition: a perpetual easement granting permanent access along the existing road. The language was precise. The boundaries were surveyed and recorded. The right didn't expire, didn't require renewal, and couldn't be revoked by anyone who bought the surrounding land afterward. It ran with the property, not with the people. I read the document 3 times, tracing my finger along the legal descriptions. Then I set it on the table and stared at the kitchen wall, thinking about what those men in uniforms didn't know. They didn't know that the ground their gate sat on belonged to an easement they had no authority over. They didn't know I had spent nearly 3 decades learning exactly how the law worked and how to use it when someone broke it. They didn't know about the shotgun in my truck either, locked in its case behind the seat, legally registered, never pointed at anyone in my life. I hoped it would stay that way. But Something about the way those guards had looked at me like I was the intruder on my own land told me this wasn't going to end with a polite phone call. I thought about my grandfather, the way he used to sit on the porch every evening and watch the light fade behind the tree line. "That road is the blood of this farm," he told me once when I was 14 and didn't understand what he meant. "Don't ever let anyone take it from you." I'd dismissed it as old man talk back then, sentimental, dramatic. But sitting in his kitchen, holding his deed, I finally understood. Someone had just tried to take what wasn't theirs. They had blocked a path protected by law, and they had picked the wrong man to test. The next morning, I called the Whispering Meadows HOA office. A woman with a voice like polished plastic answered on the third ring. I explained who I was, where my property was located, and why I needed to speak with whoever was in charge. She put me on hold for 4 minutes, then returned with the news that the board president was extremely busy, but could schedule a meeting in 5 days. 5 days of driving an extra 24 miles round trip to access my own land. I asked if there was any way to expedite. She said no. I thanked her politely, hung up, and immediately drafted an email to the address listed on the HOA website. I attached a scanned copy of my deed, highlighted the easement clause, and requested that the gate be opened within 48 hours. I sent it at 9:14 in the morning. By nightfall, no response. The meeting happened on a Thursday afternoon in a small office building at the entrance of the development. The walls displayed architectural renderings of future phases, more houses, a clubhouse, a pool that didn't exist yet. A receptionist led me to a conference room where a woman was already seated at the head of the table, reviewing papers with deliberate slowness. She looked up when I entered, smiled without reaching her eyes, and gestured to the chair across from her. "Mr. Hadley, Diane Mercer, president of Whispering Meadows, thank you for coming in." Her handshake was firm, her gaze measuring, navy blazer, gold earrings. Everything about her posture said she was used to owning rooms like this one. I didn't waste time. I placed a copy of my deed on the table and pointed to the relevant section. This easement was recorded in 1987. It grants me permanent access along the road your gate is blocking. I'm not asking for permission. I'm informing you that the obstruction needs to be removed. Diane glanced at the document like it was junk mail. I understand you believe you have certain rights, Mr. Hadley, but this road falls within our development boundaries. We've invested considerably in security infrastructure. She paused, letting the word invested hang in the air. We can't dismantle that because of a decades-old piece of paper. I told her the law didn't care how old the paper was. Her smile tightened. Legal interpretations can be complicated. Our attorneys will review your claim. Then she leaned back and folded her hands, a gesture meant to look relaxed but wasn't. In the meantime, I'd like to offer something practical. A resident access pass, $500 annually, full entry privileges, no further inconvenience. I stared at her, making sure I understood. She wanted me to pay for access to a road I already owned the right to use. A road my grandfather had secured in a binding agreement nearly 4 decades ago. I declined, told her I wouldn't pay $1 for something the law already guaranteed. The smile stayed fixed, but her eyes went flat. Your choice, but I'd encourage you to think carefully. These situations can become prolonged. As I stood to leave, she added one more thing. Your property has attracted developer interest. Mr. Hadley, strong offers. If you ever decide the farm is more trouble than it's worth, I'd be happy to make introductions. I turned back. My family has owned that land for over 70 years. It's not for sale. She tilted her head, mock sympathy. Circumstances change, just something to keep in mind. I walked out without another word. In the parking lot, one of the security guards stood near my truck, phone raised, photographing my license plate. He didn't bother pretending otherwise. That evening, I made 2 phone calls. The first, to the county recorder's office, confirming my easement documents remained intact and unchanged since filing. The second to a property attorney named Ruth Claiborne, recommended by a retired judge I'd worked with years ago. I explained the situation, emailed my documents, and scheduled a consultation for the following week. Before bed, I opened a fresh notebook and started a detailed log: dates, times, names, exact quotes, observations. If this turned into a legal fight, I intended to have records that could survive any courtroom. 3 days later, the HOA's response arrived, formal, brief, dripping with false authority. After careful review, we have determined that your easement claim lacks sufficient legal standing under current development agreements. The security gate will remain in place. Any attempt to bypass or damage HOA property will be treated as trespassing and reported to law enforcement. I read it twice, then printed it and added it to my file. They had put their position in writing, a position contradicting recorded county documents. They had threatened prosecution for using a road I had every legal right to use, and they'd stamped it with their official letterhead. I closed my laptop and looked out at the darkening sky. That black iron gate still stood across my road, but now I had something new, written proof of willful interference. People who document their own mistakes rarely understand the gift they've just handed you. The detour became my daily reality. 12 extra miles each way, 45 minutes added to every trip, roads that turned treacherous after heavy rain washouts, mudslides, gravel shifting under tires. I was 62, living alone, and the only reliable route to emergency services had been sealed behind a gate controlled by people who wanted me gone. If something happened, a fall, a heart attack, a fire, every minute would count. They had just added 15 of them to any ambulance response. The practical costs mounted fast. My feed supplier refused the alternate route. Their insurance didn't cover unpaved sections. I switched to a company 2 counties over. Delivery fees doubled. A veterinarian I'd used for years couldn't justify the extra drive time anymore. One by one, services pulled back. The isolation wasn't accidental, it was engineered. Every inconvenience was pressure designed to make me reconsider Diane Mercer's offer. The HOA didn't stop at the gate. Within 2 weeks, security patrols started appearing near my property line. White SUVs with community safety decals. Drivers watching through tinted windows. I'd see them parked at the edge of my driveway, engines running, just sitting there. Then one morning, I found trash scattered across my front pasture. Fast food wrappers, empty bottles, a torn plastic bag caught on my fence. Not windblown debris, deliberate. I photographed everything before cleaning it up. A few days later, it happened again. Different garbage, same message. Around that time, a neighbor from the development stopped me at the gas station, Helen Vasquez, a retired teacher who had moved to Whispering Meadows 3 years ago with her husband. She kept glancing around like she didn't want to be seen with me. "Mr. Hadley, there's been talk at HOA meetings about your property. Diane's telling people you're a security risk, that you've been threatening staff." I asked what exactly I was supposed to have done. Helen shook her head. "Nothing specific, just implications. She's good at that, making people feel like they're missing something dangerous without ever saying what it is." She lowered her voice. "Last week, she sent a letter to every household, called it a safety advisory about ongoing concerns with an adjacent landowner. Your name wasn't in it, but everyone knew who she meant. I asked Helen why she was telling me this. She hesitated, then looked me in the eye for the first time. "Because I've seen this before. At my last community in Florida, there was a woman just like Diane. She pushed out 3 families who didn't fit her vision. Good people. They fought for a while, then just gave up and moved away." She paused. "Some of us here don't believe what she's saying about you, but most people just go along with whatever she says. It's easier than asking questions." I thanked her and drove home, thinking about how easy it was to destroy a reputation without making a direct accusation. Diane didn't need proof. She just needed doubt. By the time I reached the farm, I'd made a decision. If they wanted a long game, I would build a record they couldn't ignore. I started with cameras, 4 units covering the road frontage, driveway, and fence line, motion activated, night vision capable. Footage is backed up to a cloud server every 6 hours. Next, I requested certified copies from the county recorder, not just the deed, but the original survey plat, the developer's acknowledgement letter from 1987, and any recorded amendments. There were none. The easement stood exactly as my grandfather had negotiated it. Then I hired a licensed surveyor named Martin Delacroix. He spent an entire day measuring boundaries, referencing the original plat, documenting everything with photographs and GPS coordinates. Afterward, he spread his findings across my kitchen table and walked me through each measurement. Walter, the road falls entirely within your easement corridor. Every inch, that gate. It's sitting on land they have no authority to obstruct. He pulled out a transparency overlay showing the original 1987 boundaries against current aerial imagery. The easement line ran straight through where the HOA had poured its concrete posts. The original developer signed an acknowledgement accepting the easement as a condition of sale. That obligation transferred to every subsequent owner, including the HOA and every homeowner who bought into the development. I asked if there was any ambiguity, any angle their lawyers might exploit. Martin shook his head firmly. This is clean. The title company should have caught this before the first house was sold. They either missed it or ignored it. Either way, the HOA has been operating on land they don't control. 2 days after Martin filed his report, I received a certified letter from the HOA's law firm, Cease. They accused me of harassing HOA personnel, conducting unauthorized surveillance, and creating a hostile environment. The letter demanded I remove my cameras, cease all contact with staff, and refrain from provocative actions. Failure to comply would result in a restraining order and civil damages. I read it twice at the kitchen table. Then I smiled for the first time in weeks. They had admitted, in writing, that they knew I was documenting them. They had accused me of surveillance while their own guards photographed my license plate, and they had threatened to sue me for asserting a right the county's own records confirmed was mine. I called Ruth Claiborne. They sent a cease, claimed I'm harassing them by installing cameras on my own land. A brief silence, then a dry laugh. Mr. Hadley, they just handed you evidence of consciousness of guilt. Save that letter. I hung up and looked out at the fading light. The pressure was real. The isolation was real. But so was the file on my desk. Timestamps, photographs, certified documents, a surveyor's report. And now a legal threat proving they knew exactly what they were doing. Ruth Claiborne's office was on the second floor of a converted Victorian house in downtown Millbrook. The kind of building that looked like it had seen 100 years of county disputes and would see 100 more. She was in her early 50s, sharp-eyed, known for winning property cases that bigger firms wouldn't touch. I'd called her on a retired judge's recommendation, and within 10 minutes of sitting across from her desk, I understood why. She didn't waste words. She didn't soften edges. She looked at problems the way a surgeon looks at tumors: identify, isolate, remove. She spent 45 minutes reviewing my documents, the deed, the survey report, the HOA's correspondence, the cease and desist letter. When she finished, she set everything down in a neat stack and looked at me with something close to satisfaction. Mr. Hadley, you have an exceptionally strong case. The easement is recorded, perpetual, unambiguous. The survey confirms the gate sits entirely on land they have no authority to obstruct. She tapped the cease. This is particularly helpful. They're accusing you of harassment for documenting their actions on your own property. That's not weak, it's evidence of bad faith. I asked what my options were. She leaned back. Injunctive relief to force the removal of the gate. Damages for actual costs you've incurred. Punitive damages if we prove willful interference. She paused. Given their conduct after receiving formal notice, I'd say we can. And here's what makes this interesting. They've been so focused on intimidating you that they've created a paper trail of their own misconduct. Every email, every letter, every patrol report, all of it works in your favor now. I told her to proceed. We drafted a civil complaint that afternoon: easement violation, intentional interference with property rights, tortious conduct. Ruth also prepared a formal notice demanding gate removal within 30 days, along with a separate complaint to the county building department about unauthorized construction on easement land. By the time I left her office, the counterattack was documented, filed, and moving through the system. 3 days later, I drove to the gate to deliver the formal notice in person. I wanted it hand-delivered, witnessed, and time-stamped. I also wanted to look Diane Mercer's guards in the eye when they realized the rules had changed. It was a Tuesday morning, cool and clear. My shotgun was in the truck-locked case, behind the seat, same as always. I hadn't touched it in weeks, wasn't planning to that morning either. The guard saw me coming before I reached the gate. The taller one stepped into the road with his hand raised. His partner hung back near the guardhouse, already reaching for his phone. I rolled down my window and held up the envelope. I'm here to deliver legal documents to the HOA. Formal notice regarding the easement your gate is obstructing. The tall guard didn't move. Sir, you need to exit the vehicle. I told him I wasn't required to do that. I was on a public right-of-way delivering legal correspondence. He repeated himself, louder. Exit the vehicle now. His partner was talking into his phone, voice too low to hear. I stayed where I was, hands visible on the steering wheel, envelope on the dashboard, within 8 minutes. A county sheriff's cruiser pulled up behind me. The deputy who stepped out was Tom Kendrick, 15 years younger than me, someone I'd trained during his first year on the job. He looked surprised to see me, then confused, then cautious. Walter, what's going on here? Before I could answer, the tall guard cut in. This man threatened us with a firearm. He's got a gun in the vehicle. Tom looked at me. I kept my voice level. There's a shotgun in a locked case behind my seat. Registered, legal. I haven't touched it. I'm here to deliver court documents. Tom nodded slowly, walked to my truck, and asked if he could inspect it. I said yes. He opened the rear door, checked the case still locked, still latched, and closed it again. He turned to the guards. The weapon is secured and legal. No violation. The tall guard's face went red. He threatened us. Said he'd use it if we didn't let him through. I didn't raise my voice. That's a lie, and your body cameras recorded everything. The guards exchanged a glance. Tom caught it. You do have body cameras, right? I saw the mounts. A long pause. The shorter guard muttered, Yeah, we do. Tom nodded. Good. I'll need copies of that footage, for the report. He walked back to me, voice lowered, so only I could hear. Walter, I don't know what's going on with these people, but that story they just told doesn't match anything I saw when I pulled up. You were sitting in your truck with your hands on the wheel. He shook his head slightly. Be careful. Something's off here. He handed me back my registration, told me I was free to go, and stepped aside. I handed the envelope directly to the tall guard, made sure he acknowledged receipt, and drove through the gate for the first time in months. That evening, Diane Mercer posted online, Security alert, armed individual made threatening statements at the community gate. Law enforcement contacted. Remain vigilant. The comments exploded. Dangerous. Unstable. Why isn't he arrested? I read through them without responding. Responding wasn't the play. The footage was. I called Ruth that night. They filed a false report. The deputy requested their body cam footage. She was quiet for a moment. Add defamation to the complaint. Send me everything on that community post. If they lied to law enforcement and repeated it publicly, we're not just talking property rights anymore. We're talking criminal exposure. I hung up and sat in the dark, thinking about the guards' faces when Tom asked about the cameras. They had expected the shotgun to be my weakness. They didn't realize it was about to become theirs. The preliminary hearing was scheduled for a Thursday morning, 6 weeks after Ruth filed the complaint. I arrived at the county courthouse at 8:15, wearing the same suit I'd worn to my wife's funeral, dark gray. Conservative, the kind of thing that said I took this seriously without trying too hard. Ruth met me in the lobby with a leather briefcase thick with documents. She looked calm, but I could see the focus in her eyes. This was the moment everything we'd built would either hold or collapse. The courtroom was smaller than I expected. Wood-paneled walls, fluorescent lights that buzzed faintly overhead, a handful of observers in the gallery, a few curious locals, a reporter from the county newspaper, and near the back, Helen Vasquez. She gave me a small nod when our eyes met. I nodded back. On the other side of the aisle sat Diane Mercer, flanked by 3 attorneys in matching charcoal suits. A big firm from the city, the kind that charged $500 an hour and counted on opponents being intimidated by the sheer weight of their presence. Diane looked polished as always. Navy blazer, gold earrings, a smile that didn't reach her eyes. She glanced at me once, then looked away like I wasn't worth her attention. The judge was a woman in her 60s named Patricia Holbrook. She had a reputation for efficiency and zero tolerance for theatrics. When she called the session to order, the room went silent immediately. Ruth presented our case, first the deed, the recorded easement, the survey report, and the correspondence showing the HOA had been formally notified and refused to comply. She laid out the timeline clearly, methodically, letting the documents speak for themselves. Judge Holbrook followed along, occasionally making notes, asking clarifying questions that showed she understood exactly what was at stake. Then it was the HOA's turn. Their lead attorney, a tall man with silver hair and a voice designed for jury persuasion, stood and began his argument. Your Honor, the plaintiff's claim rests on a document from 1987 that predates the current development agreement. The Whispering Meadows community represents a significant investment in modern infrastructure, security, and property values. The so-called easement was never properly integrated into subsequent title transfers and should be considered abandoned under the doctrine of non-use. Ruth didn't flinch. She'd anticipated this. When she stood for rebuttal, her voice was steady. Your Honor, the easement was recorded with the county and has never been extinguished. My client has used this road continuously for 37 years. The doctrine of abandonment requires clear evidence of intent to relinquish, which does not exist here. Furthermore, the original developer signed an acknowledgement letter accepting the easement as a condition of the 1987 sale. That obligation transferred to every subsequent owner, including the HOA. Judge Holbrook turned to the HOA's attorneys. Do you have documentation showing the easement was legally extinguished or superseded? The silver-haired lawyer hesitated. We're still compiling our title research. Your Honor. The judge's expression didn't change, but her tone sharpened. You've had 6 weeks to prepare for this hearing. Either the documentation exists, or it doesn't. Silence. Behind him, I saw Diane's smile falter for the first time. Then Ruth played her second card. Your Honor, there's an additional matter we'd like to address. On the date my client attempted to deliver formal notice to the HOA, security personnel filed a report with the county sheriff, alleging that Mr. Hadley threatened them with a firearm. We have obtained body camera footage from those same security officers that directly contradicts their account. She handed a USB drive to the clerk, who connected it to the courtroom's display system. The screen flickered to life. The footage was clear, steady, unedited. It showed me sitting in my truck, hands on the steering wheel, an envelope visible on the dashboard. The audio captured every word my calm explanation. The guard's escalating demands, his phone call claiming I had threatened them with a gun. At no point did I raise my voice. At no point did I reach for anything. At no point did the shotgun leave its locked case. The video ended with Deputy Kendrick inspecting the case and confirming no violation had occurred. The courtroom was silent. Judge Holbrook watched the entire recording without expression, then turned to the HOA's attorneys. Counsel, your clients appear to have filed a false report with law enforcement. Do you have an explanation? The silver-haired lawyer stood frozen. Behind him, Diane Mercer leaned forward and whispered something urgent. He waved her off. Your Honor, we were not aware of the full context of that incident. We'll need time to review. The judge cut him off. You'll have time, but I've seen enough for today. She issued her ruling, a temporary injunction requiring the HOA to open the gate and allow my access immediately, pending final resolution of the case. She also ordered the body camera footage to be forwarded to the county prosecutor's office for review of potential false report charges. As she spoke, I watched Diane Mercer's face cycle through disbelief, anger, and something that looked almost like panic. She grabbed her lead attorney's arm and whispered furiously. He pulled away, jaw tight, clearly unhappy with whatever she was saying. The polished facade was cracking. Outside the courthouse, Ruth and I stood on the steps while the HOA's legal team hurried past without making eye contact. That went well, she said, allowing herself a small smile. The injunction is temporary, but it shifts the momentum. They know they're exposed now on the easement and on the false report. Their next move will be desperate. I asked her what she expected. She looked toward the parking lot, where Diane Mercer was climbing into a black SUV, phone already pressed to her ear. Escalation. People like her don't back down when they're cornered. They double down. She turned back to me. Stay documented. Stay calm. And don't give them anything they can use. I drove home that afternoon on my road. No guards. No gate blocking my path. The iron bars had been swung open, held back by chains that looked hastily attached. I slowed as I passed through, looking at the concrete posts, the security camera still blinking overhead, the empty guardhouse. It felt strange, not triumphant, just strange, like walking through a door that should have never been locked in the first place. The road was the same as it had always been. The dip near the old oak, the cracked asphalt, the long curve toward home. 37 years I'd driven this path, and for the first time in months, no one stood in my way. News of the hearing spread through Whispering Meadows faster than I expected, within 48 hours. The county newspaper ran a story with the headline, HOA Gate Dispute Heads to Court Security Footage Raises Questions. The article was factual, carefully worded, but the implication was clear: the HOA had overreached. I didn't give any interviews, didn't need to. The documents spoke for themselves, but I noticed something shift in the days that followed. Fewer patrol cars near my property line, fewer hostile glances when I drove through the open gate, and more than a few residents who suddenly couldn't meet my eye. Diane Mercer responded the way Ruth predicted by doubling down. 3 days after the hearing, she sent an email blast to every household in the development. Helen Vasquez forwarded me a copy without comment. Subject line, "Urgent protecting our community." The message accused me of weaponizing the legal system to undermine safety and property values. It called for an emergency HOA meeting that Saturday. It announced 2 additional security officers to ensure resident safety during this difficult time. No mention of the body camera footage, no mention of the injunction, no mention of the county prosecutor now reviewing criminal charges against her own staff. The guards cracked first. Ruth called me on Tuesday with the update. The prosecutor moved fast. Both security officers charged with filing a false police report, Class 1 misdemeanor, up to 12 months and $2,500 each. She paused. One of them hired his own attorney and started cooperating. He's claiming Diane personally instructed them to do whatever it takes to keep you off that road. He's got emails. I asked if those would be admissible. Ruth's voice carried a note of satisfaction. They're already part of the prosecutor's file. I've subpoenaed copies for our civil case. If they show what he says they show, we're proving conspiracy. I asked Ruth to walk me through what this meant for our strategy. She took a breath and laid it out. Right now, we have 3 separate tracks running. First, the civil case easement violation, interference with property rights, tortious conduct, that's proceeding regardless of anything else. Second, the criminal charges against the guards. If one of them testifies that Diane directed the false report, she becomes exposed to the same charges, potentially worse. Solicitation of a false police report is a Class 6 felony in this state, up to 5 years. She let that sink in. The third track is the HOA's internal exposure. If Marcus Webb is right about the financial irregularities, unauthorized legal fees, unapproved security contracts that opens the door to breach of fiduciary duty claims from homeowners themselves, Diane could face lawsuits from her own community. I asked what she recommended. We stay the course, document everything, let the prosecutor build the criminal case, let the community fracture on its own. Our job is to be ready when this goes to trial and to make sure the record is so clean that no appeals court can touch the verdict. The community meeting happened on Saturday as scheduled. Helen called me that evening with a full report. It fell apart. Walter. She started her usual speech about security and property values. Then Marcus Webb, the accountant on Maple Lane, stood up and asked about legal fees. How much had the HOA spent? Why weren't homeowners consulted? He said he had reviewed the quarterly statements. The legal expenses weren't itemized. The security contract wasn't board approved. Helen's voice dropped. He accused her of misappropriating funds without authorization. That's when she snapped. I asked what happened. She started shouting that she was the only one protecting everyone, that if you won the lawsuit, property values would collapse. People just stood up and left, walked out while she was still yelling at empty chairs. Helen paused. Someone recorded it, videos already circulating. I watched the footage that night, shaky phone quality, background noise, but Diane's voice cut through clearly. I am protecting all of you. Everything I've built here will be destroyed. The camera panned to show residents filing toward the exit. The video ended with her standing alone at the podium, still talking to an empty room. The community fracture deepened over the next few days. Helen kept me updated. The petition for an independent audit had gathered 43 signatures, more than half the households. A second petition was circulating to call a special election for new board leadership. 3 families had listed their homes for sale, citing community instability to their realtors. One resident, a retired attorney named Donald Kemp, sent a formal letter to the HOA's law firm demanding an itemized accounting of all legal expenditures. The firm responded by withdrawing from representation, effective immediately. Ruth called the next morning with confirmation. Their lawyers are gone, filed a motion to withdraw yesterday afternoon, cited breakdown in attorney-client relationship. That's legal speak for, our client won't listen to us, and we don't want to go down with her. She paused. Diane will have to find new counsel before the trial. That buys us time, but more importantly, it signals to the court that even her own attorneys don't believe in her case anymore. The unraveling accelerated. 2 board members resigned, citing irreconcilable differences with HOA leadership. Helen told me several residents had approached her privately, asking if there was a way to settle without further litigation. They were embarrassed, worried about their own exposure. They wanted the whole thing to disappear, but quiet wasn't an option anymore. The prosecutor had filed charges, the civil case was proceeding, the emails were on record, and somewhere in her perfectly decorated home, Diane was watching everything she'd built collapse around her. I didn't feel satisfaction. What I felt was exhaustion, the bone-deep tiredness of a man who had spent months defending something that should never have needed defending. Diane had doubled down on threats, spending, and lies. Every move dug her hole deeper. I didn't need to push anymore. I just needed to stand still and let gravity do its work. The trial was scheduled for a Tuesday in late October, 4 months after the preliminary hearing. The morning was cold and gray, the kind of autumn day that felt like the sky itself was holding its breath. I arrived at the courthouse at 7:45, earlier than necessary, and sat in my truck watching people filter through the entrance. Lawyers with briefcases, clerks with coffee keys, ordinary citizens summoned for jury duty, most of them looking like they'd rather be anywhere else. Somewhere in that building, 12 of those people would decide whether the past year of my life had been worth the fight. I finished my coffee, straightened my tie, and walked inside. The courtroom was larger than the one used for the preliminary hearing. Higher ceilings, more gallery seating, a proper jury box along the side wall. Ruth was already at the plaintiff's table when I entered, organizing documents with the focused calm I'd come to recognize as her pre-trial mode. Martin Delacroix sat in the front row of the gallery, ready to testify as our expert witness. Behind him, I spotted Helen Vasquez, Marcus Webb, and a handful of other Whispering Meadows residents who had made the drive. They weren't required to be there. They came anyway. The defense table told a different story. Diane Mercer sat alone with a single attorney, a younger man I didn't recognize, clearly a last-minute replacement after her original firm withdrew. He looked nervous, shuffling papers without apparent purpose, glancing at his client like he wasn't sure what she might do next. Diane herself was dressed immaculately as always, but something had changed. The confidence was gone. Her posture was rigid, her jaw tight, her eyes fixed straight ahead as if looking anywhere else might cause her to shatter. Judge Holbrook called the proceedings to order at 9 sharp. The jury had been selected the previous week 7 women, 5 men, ages ranging from mid-20s to early 70s. Ruth had been pleased with the composition. Property owners, she'd told me, people who understand what it means to have someone try to take what's yours. Now she rose to deliver her opening statement, her voice clear and measured as she laid out the case. The recorded easement, the illegal obstruction, the harassment campaign, the false police report, the conspiracy to deny a man access to his own land. She spoke for 12 minutes without notes, weaving the facts into a narrative that even I found compelling, despite having lived through every moment of it. The defense attorney's opening was brief and unfocused. He talked about community standards, security concerns, the need to balance individual rights against collective interests. He never directly addressed the easement. He never explained why the gate had been built on land the HOA didn't control. When he sat down, I saw one of the jurors, a woman in her 50s with reading glasses pushed up on her forehead, shake her head almost imperceptibly. Ruth called Martin Delacroix first. He walked the jury through his survey findings with the patience of a man who had testified in dozens of cases. The easement boundaries, the location of the gate, the original developer's acknowledgement letter from 1987. He produced the transparency overlay showing the property lines against the current aerial imagery. The gate sits entirely within the recorded easement corridor, he concluded. The HOA had no legal authority to construct any permanent structure on that land. The defense attorney attempted a cross-examination, but succeeded only in having Martin repeat his conclusions more emphatically. Then came the emails. Ruth had saved them for maximum impact. She projected them onto a screen visible to the jury, reading the key passages aloud. Diane Mercer's instructions to the security guards. Do not allow him through under any circumstances. If he causes trouble, call the police and report him as a threat. We'll handle the rest. The follow-up message sent the morning after my arrest didn't happen. Why wasn't he taken into custody? I need an explanation. And finally, a thread discussing how to accelerate pressure on my property through code enforcement contacts and media outreach regarding safety concerns. The courtroom was silent. Several jurors were taking notes. One was staring at Diane with unconcealed disgust. Ruth called Diane Mercer to the stand. It was a calculated risk. Hostile witnesses can be unpredictable, but Ruth had prepared for every contingency. She started with simple questions. When did you become HOA president? When was the gate approved? Did you review the title documents before construction? Diane answered tersely, her voice flat, giving nothing away. Then Ruth shifted. Ms. Mercer, did you send this email instructing security personnel to report Mr. Hadley as a threat regardless of his actual behavior? Diane's attorney objected, overruled. Diane stared at the screen for a long moment. I was trying to protect my community, Ruth pressed. That wasn't my question. Did you send this email? Another pause. Yes. The word hung in the air like smoke. Ruth continued, methodical and relentless. Each question built on the last, each answer tightening the noose. Did you know the gate was built on easement land? Our attorneys advised us the easement was no longer valid. Did you obtain a written legal opinion to that effect? I don't recall. Did you authorize expenditures for legal defense without board approval? I had emergency authority. Did the HOA bylaws grant you emergency authority for expenses exceeding $10,000? Silence. Ms. Mercer. Diane's composure finally cracked. I was the only one trying to protect this community. Everyone else just sat there while that man threatened our safety, our property values, everything we built. Someone had to act. Judge Holbrook gavelled for order. The defense attorney dropped his head into his hands. The jury deliberated for less than 3 hours. When they returned, the foreperson, a retired teacher with kind eyes and steady hands, read the verdict. Liable on all counts. Actual damages $47,000 for economic losses, including increased transportation costs, lost business, and emergency service delays. Punitive damages $150,000 for willful interference with property rights. Legal fees and court costs $85,000. Total judgment $282,000. The court further ordered the immediate and permanent removal of the gate, with a perpetual injunction prohibiting any future obstruction of the easement. Judge Holbrook addressed the courtroom before dismissing the jury. The evidence in this case demonstrates a pattern of deliberate misconduct by HOA leadership. The court has referred relevant materials to the county prosecutor for consideration of additional charges. She turned to Diane. Ms. Mercer, I strongly advise you to retain criminal defense counsel. Diane sat motionless, staring at nothing. Outside the courthouse, a reporter approached me with a microphone. Mr. Hadley, how do you feel about today's verdict? I thought about the question, about the months of detours and harassment, about the guards who lied, about the neighbors who believed them, about my grandfather's voice telling me never to let anyone take that road. I didn't want to fight, I said finally. I just wanted to go home. The law gave me that right 67 years ago. Today, the court confirmed it. The reporter waited for more. I had nothing else to add. Ruth touched my arm, and we walked together toward the parking lot, leaving the cameras behind. The weeks following the verdict moved slowly, like the last days of a long illness finally breaking. I spent most of them on the farm, catching up on work I'd neglected during months of legal preparation. Fences that needed mending, equipment that needed servicing, a barn roof that had started leaking sometime during the summer and never got fixed. The physical labor felt good, honest, tangible, the kind of work where you could see the results at the end of each day, after so long fighting something I couldn't touch. There was comfort in problems I could solve with my own hands. The legal aftermath unfolded without my direct involvement, though Ruth kept me informed. The county prosecutor moved forward with charges against Diane Mercer, solicitation of a false police report, a Class 6 felony carrying up to 5 years in state prison. She hired a criminal defense attorney, an expensive one from what I heard, and began negotiating a plea deal almost immediately. The final agreement came through in early December, guilty plea to a reduced charge of conspiracy to file a false report, 18 months of supervised probation, $25,000 in fines, and 200 hours of community service. She also agreed to resign from all HOA positions permanently and surrender her real estate license as part of a separate settlement with the state licensing board. It wasn't prison, but it was enough. Her career was over, her reputation was destroyed, and she would spend the next year and a half explaining to a probation officer why she'd tried to ruin a man's life over a road she never had the right to block. The 2 security guards received their own consequences. Both pleaded guilty to filing false police reports, 6 months probation each, $5,000 in fines, and permanent notes on their records that would follow them to any future employment. One of them, the shorter one who had cooperated with prosecutors, sent me a letter through Ruth's office. It was brief, handwritten, and surprisingly sincere. He apologized for lying, said he'd known it was wrong at the time but felt pressured by Diane and afraid of losing his job. He didn't ask for forgiveness, he just wanted me to know he was sorry. I read the letter twice, then put it in a drawer. I didn't write back. Some things don't require a response. The HOA itself underwent a complete transformation. The board that had enabled Diane's conduct was swept away in a special election held 3 weeks after the trial. Marcus Webb, the accountant who had first raised questions about financial irregularities, was elected president by a margin of nearly 3-1. His first official act was commissioning an independent audit of all HOA expenditures over the previous 2 years. The results were damning unauthorized legal fees totaling over $90,000, security contracts signed without board approval, and a series of questionable payments to vendors that turned out to be companies owned by Diane's relatives. The new board voted unanimously to pursue civil action against her for breach of fiduciary duty. As of my last conversation with Helen, that case was still pending. The gate came down on a Saturday morning in November, exactly as the court had ordered. I didn't go watch, didn't need to. Helen called me when it was done, her voice carrying a mixture of relief and something like embarrassment. "It's gone. Walter, they hauled it away an hour ago. The concrete posts, too. You'd never know anything was ever there." I thanked her for letting me know. She hesitated, then added, "I'm sorry it took so long. I'm sorry we didn't see what she was doing sooner." I told her it wasn't her fault. Most people trust the systems they live in. That's not a flaw, it's just human nature. The flaw is in the people who exploit that trust. The compensation money arrived in 3 installments over the following months. After Ruth's fees and court costs, I netted just under $160,000. I didn't spend it frivolously. Most went into the farm new fencing along the entire property line, a proper security system with cameras and motion sensors, repairs to the barn and outbuildings that had been waiting years for attention. I also set aside a portion for emergencies, the way my grandfather had always taught me. Land doesn't mean nothing if you can't hold on to it, he used to say. I'd held on to mine. Now I intended to make sure no one could threaten it again. I had a new sign made and installed it at the entrance to the easement road, right where the gate used to stand. Simple black letters on a white background, "Private road easement holder rights protected by law." Below that, in smaller text, is a reference to the county recording number of my deed. It wasn't a threat, it was a statement of fact. Anyone who drove past would know exactly what they were looking at, and exactly what had happened to the last people who tried to pretend otherwise. My daughter drove up from Raleigh for Thanksgiving that year, bringing her husband and both boys. It was the first time I'd had family on the farm since everything started. We cooked too much food, played cards until midnight, and spent an entire afternoon teaching the boys how to split firewood without losing any fingers. On their last morning, my daughter found me on the porch, coffee in hand, watching the sunrise paint the tree line gold. She sat down beside me without speaking, and we stayed like that for a while, just breathing the cold air and listening to the birds wake up. Finally, she said, "I'm proud of you, Dad, for fighting, for not giving up." I didn't know how to respond, so I just nodded. Some things don't need words either. Spring came early that year. By late March, the pastures were green again, the creek was running full, and my road was exactly as it had been for 67 years. I drove it every day without thinking about gates or guards or courtrooms. The muscle memory of conflict slowly faded, replaced by the ordinary rhythms of farm life. Wake up, feed the animals, fix what's broken, watch the sun go down, repeat. One afternoon in April, I was walking the fence line when I heard a vehicle slow on the main road. I looked up to see an unfamiliar pickup truck turning onto the easement, a young couple in the front seat, and out-of-state plates. They stopped in when they saw me and rolled down the window. The driver, a man in his 30s with a nervous smile, called out, "Excuse me, sir, is this a private road? We're looking at property in the area and weren't sure if we could drive through." I walked over and leaned against their door, looked at the road stretching behind them, the same road my grandfather had walked with my grandmother, the same road I'd driven for 37 years, the same road someone had tried to steal from me with an iron gate and a stack of lies. "It's an easement road," I said. "That means anyone with legitimate business can use it. You're fine." The young man thanked me, and his wife asked if I lived nearby. I pointed toward the tree line. 45 acres, just past that hill. Been in my family since 1951. She smiled. "That's wonderful. You don't see that much anymore, families holding on to land that long?" I nodded. "No, you don't." They drove on, and I stood there for a moment, watching the dust settle behind them. I thought about everything that had happened: the gate, the lies, the courthouse, the verdict, the months of exhaustion and doubt and cold, patient anger, and I thought about what I'd learned, not about law or property rights or HOA corruption, but about something simpler. Some things are worth fighting for, not because they're valuable to anyone else, but because they're yours, because someone trusted you to protect them, because giving up would mean betraying everything that came before. I turned and walked back toward the house. The afternoon sun warm on my shoulders. The road behind me was open, the road ahead was clear, and for the first time in a long time, I felt like I was exactly where I was supposed to be,